Call to order the Policy Committee meeting for July 18th, 2017. We have two items on the agenda today. We'll start with JBA, Non-Discrimination of Students.
Good afternoon. My name is Clarence Parker. I am the EEO and Title IX manager for city schools, and today is my presentation on the revisions, proposed policy revisions to JBA, JBRA, policy JBB, and policy JBBRA. So just to give a little background, in the past, the two issues that we're discussing today, student discrimination was covered in policy ACA, and sexual harassment was covered in policy I'm sorry, I had it backwards. Student discrimination was covered in policy ACC, and the sexual harassment policy was covered in policy ACA. So today we're going to talk about, I just want to highlight the principal parts of the revisions that we're proposing. First of all, we're proposing to remove reference of students from policy ACA, and let me get my thing. It's ready. No? Thank you. Okay. And then this one. Okay, thank you. Okay, so to start off, we're proposing to remove reference from students from ACA. As you know, ACA was adopted last summer, and it addresses now employees, workplace employment issues. So we are proposing to remove references to students from policy ACA. We're adding gender expression and gender identity as protected categories. We want to create a separate non-discrimination policies and alternative regulations to cover students in discrimination. We want to establish a clear complaint process for investigating student allegations of discrimination and harassment. We want to make student discrimination policies clear and easier to find for students, parents, and school-based staff. And we want to ensure that the policies and procedures are compatible and in compliance with Title IX.
Can you just clarify, and I may have missed it because I was pulling things up,
Sure.
policy JCA?
I'm sorry.
Your reference?
ACA, I'm sorry. So there's previously an ACA.
Right.
So now this would be moving it into JBA.
Perfect. Okay, I just wanted to make sure I was tracking that I hadn't
Right.
missed something along the way.
And so I'm going to just highlight these. We want to provide a resource also for students who experience discrimination and harassment in city schools by city school employees and third parties, which was not previously addressed in policy JIC. Okay, in the non-discrimination policy for students itself, we're adding protection on the basis of sexual orientation, gender identity, and gender expression. They are protected categories that were not in the previous JCA policy.
So if I can just clarify a bit for the record, the purpose of today's hearing or policy is really just to clarify the discrimination investigative practices with regard to students. Previously, as you know, all of the policies, ACA, address both employees and students. And what we learned is that folks at the schoolhouse had difficulty maneuvering where the policies were. So this is really an attempt to make sure that policies related to students are in the student section, which is section J, and employees are in section A. policy ACA did not change last year, with the exception of taking out references to students. And what you'll see in the presentation with regard to JBA is many of the additional language, or much of the additional language that's added, is for purposes of clarification. So this board, through its policies, has always protected students from discrimination based on sexual orientation, gender identity, and those sort of things. But it fell under the catch-all category of sex and gender discrimination. So these are not new substantive changes, it's just a different way of approaching the work.
Thank you for that.
Thank you. So we're going to go to slide number 5. Again, just to highlight the policy standards in section 1. It includes employees who allow or prohibited for employees or students or staff who allow or tolerate discrimination or harassment. They're now subject to discrimination. To disciplinary action, retaliation against any student for filing such a complaint or participating in the investigation as a result will also be subject to discrimination. And number disciplinary action. Sorry, a little nervous. Okay. Move to slide number 6. We're going to talk about who can file a complaint. Students, parents, guardians may file a complaint against any city school employee or third party based on a protected category. Filing a complaint can be done by submitting it to the principal. The principal notifies EEO and Labor Relations on that same day, or they may file directly with EEO or the Title IX office using the JBA RA Form 1. And of course, at any time, they may file a complaint with the U.S. Department of Education Office of Civil Rights or any external enforcement agency.
Okay, thank you. I have a question. Okay.
Commissioner Medema, we're going to allow, since it's his first time presenting, we're going to let him get through it and then ask questions for him at the end.
Okay, through the entire
Presentation, yeah, on this policy.
Okay.
Thanks.
Slide 7 talks about the investigation of the complaints. And the accused party, employee or staff person will be notified in writing, and of course, they may produce evidence and have a right to representation. The EEO office will identify and interview witnesses and documents. And if there is a violation to the policy, our findings will be forwarded to Labor Relations for appropriate follow-up action. And roles and responsibilities on slide 9. Talks about the roles of principals. They disseminate the policy. They enforce and ensure discrimination in their workplaces are promptly addressed. We expect them to recognize active discrimination and take prompt and effective action, and to promptly respond to complaints of discrimination and take the necessary action to effectively address it. The roles and the responsibility of the EEO office on slide 9. Of course, we investigate complaints and maintain the confidentiality of records. We are responsible for explaining the policies and the procedures to the complainant, the accused, and to witnesses. And we provide guidance and advice to principals on discrimination and harassment procedures. On slide 10, the the Office of Labor Relations, in cases of harassment and discrimination, they decide whether or not the employee should remain in their assigned workplace during the investigation, and of course they take appropriate level of disciplinary action, which may and be up to and including termination. And of course, city school employees are expected to fully cooperate in the investigation, and that would conclude JBA and JBRA. Questions?
If you're ready, sure. Commissioner Bodema, you want to ask your
Yes.
question?
Let me go back to, I'd like to go back to slide 6, please. Can you hear me? Yes, I think I'm close enough. When you're filing and you're using EEOC and first you're filing with the principal and you're filing with EEOC, do you have somewhere in any document or handout that shows the timeline that you have to file? I know you said it the same day for the principal.
Right.
But do you have to show the timeline for EEOC because, EEO, I'm
No,
thinking
yeah,
of.
that would be, we're referring to my office.
It's documented somewhere with the timeline that you have to file, because I know it's deadlines on each time that you file. So do you have it written where the principal or anybody can see the amount of days that they have to file before you cannot file again or cannot file at all? Because I know in some instances you have to 180 days.
Right, so you're really talking about a statute of limitations.
That's
That is not in
right.
the policy, but we can certainly add it for purposes of clarification.
I think that's critical,
Okay.
because what happens, that I was the chair of Community Relations Commission,
Mhm.
and EEOC with them, and if they don't file in the same circumstances, you have X amount of time and time limit to file.
Correct.
If you miss that time, you cannot do it.
That's correct.
You cannot file. So I think it's kind of important that we include that, because many times people want to file, and all of a sudden, they miss the time. So I think that's critical.
Commissioner Canham?
Thank you. My question was around the students who wanted to file a complaint. What are the resources that are available for students? It wasn't clear to me if a student is experiencing this, how do they, and what resources do we support them to file the complaint? And what if they are experiencing the discrimination they are feeling from the principal themselves?
So, and I think that's addressed a little bit in JBB on the sex discrimination, the sexual harassment part. But essentially, if the principal, who is the frontline person, is in a position where they can't effectively address the complaint, then they come directly to my office. So
But how is a student supposed to know to come to your office?
So that is actually in the policy,
Mhm.
although not spelled out in this presentation.
Yeah, okay, I looked for that. I didn't, okay, I'll look. Right, but I'm thinking of a middle school student. I'm actually getting to the point, like, how are we training, like, how are students exposed, and how we train the staff to understand what the procedure is? I understand there's a form and it goes to your office, but if a kid's experiencing that and doesn't know that at all, it's never going to happen.
So a part of the policy, I think, is a responsibility in my office. We have to actually draft language, school-appropriate language, to advise students of their rights and protections under these policies.
So does that, like, go out in the student handbook? Do we outline
It'll be in
that
student
somewhere?
handbooks, it'll be in publications, a number of ways that we're going to try to get that out to students and their parents.
Do we outline that? Should we
It's in
outline
the
that?
policy.
So
It's in the policy?
Yeah, to build on that question, in a previous slide, you mentioned that your office trains the principals. Do you train
Yeah.
them then expressly saying, this is what you have to share with your staff in the first 3 days of school? Or is there a procedure for ensuring that the information is getting down to staff? And then the next step, obviously, is getting
Yes.
down to students.
Yeah, I was wondering the same question.
So I would say yes. The policy provides that the Office of EEO and Title IX compliance is to provide principals with that training. In addition, there is also a provision that we are to provide a summary of these policies in any publication that's disseminated to the student population. And we're guessing that will be the family guide that goes home every year.
Right. In the fall.
Thirdly, the Office of EEO will provide or work with principals to have a statement that they can include in school-based handbooks, which will go home with children. So there'll be at least 2 written means by which students will be advised of JBA and JBB. It'll also be on our website, and then we'll have principals trained in administering the policy. There's also the safety check of policy JIC, which is bullying and intimidation of children. And they're allowed to make a complaint of bullying or harassment to any staff member. So it is the expectation of city schools, I believe, that all staff members understand how to handle harassment and discrimination complaints through JIC policy. JIC will also, and Clarence will be working with the policy sponsor on that provision to ensure that they collaborate with the Office of EEO so that we can meet our Title IX requirements.
So also in the policy is that they couldn't report to an external agency as well.
They are, and we are
So-
required to include
So
that
if we make
language
sure
by
students
law.
know that, especially if it's a person of sort of power in their building, they may want to go elsewhere. One quick verb check. You mentioned that the statement would be put forward to principals so that they could include it. They
Will.
must, and, just
Yes.
to
Okay.
make that clear. Thanks.
And this is right now, I'm not sure if you have this, procedure, but I recommend that maybe not this year, but at some point evaluate the fact that even though you tell, and you talk to principals and you talk to teachers and you speak with students in reference to the policy, it would be a great advancement if at some point we could have a document with all this information, just like what you have. And after speaking to the principals and everybody, the staff, they sign a document that they have heard this information. Because from my experiences dealing with people who don't know or who actually have heard it, but claim they have not heard it, or they did not read it and didn't understand something, when we have a signed document that is in the file, we will know that these people, the employees have heard and received this information about the policy, and it's put away, because it really does save us a whole lot of energy, and if anything should happen, it saves us a whole lot of issues in reference to legality.
So we're doing that now for
Oh, okay.
policy ACA, which is the anti-discrimination policy for employees. There is a web-based training module that all
Okay.
employees are required to complete, and then Clarence works with our IT department to see where employees have not met the expectation. They're given notices, and I just don't want to say what those notices are on the record, because then we'll have everybody waiting until the last minute
Exactly.
to complete the training. But where training is not completed within a defined timeline, then we send that information to the Office of Labor Relations, and letters are sent to the employees advising them that they will be charged with insubordination and or neglect of duty should they fail to follow through at that time.
So we're on the right track then, because you're doing it.
Yes.
Okay, and I say this because we know that at some point, issues could occur and something legal could happen, and people will say that I didn't know anything about it, and I didn't have any workshop, I didn't have anything. And this way, we are really clear that they have signed a document, and yes, you did, and here it is. So, thank you, appreciate it.
Okay, thank you. We're moving to slide 11, which talks about proposed policy JBB. JBB is an update and a replacement policy for policy ACC, which is sexual harassment of students. So this is an update and replacement for that policy. As this says, Title IX requires that we address discrimination based on sex, sexual violence, discrimination based on sexual orientation, and discrimination based on failure to conform to sexual stereotypical notions of masculinity and femininity. OCR, Office of Civil Rights, also mandates that we identify a Title IX coordinator to oversee sex discrimination investigations, notice requirements, confidentiality, and timelines, and that would be my role. This policy, again, is moved to Section J to ensure that administrators, school-based staff, and students and parents can easily access it. The highlights of these revisions, it gives, we included options to provide assistance from the Baltimore Police Department and the Rape Counseling Rape Crisis Center in events of sexual harassment or sexual violence. We also include grievance protocols. It identifies, again, the Title IX coordinator as myself, and it has identification and contact information. It addresses all forms of sex-based discrimination, including sexual violence. Upon receipt of the complaint, principals must contact the Title IX coordinator to oversee the investigations. So the details of the process is primarily that the principal, and this is a question that you had asked earlier, is that the principal or the principal designee conducts the investigation with the oversight from the Title IX manager. If the principal is the accused or unable to conduct an unbiased or effective investigation, then the Title IX coordinator steps in and conducts that investigation. It also outlines our grievance process and the investigatory process for harassment by a third party or city school employee. It says who can file, student, guardian, they can file a complaint, either with a responsible employee, which would be an administrator or manager or supervisor, or file directly with me using the Title IX, the JBB form RA. They must report the victim. The responsible employee must report the victims to the principal within 1 business day. They must notify the Title IX coordinator within 1 business day, and the Title IX coordinator notifies labor relations in 1 business day. And again, the Title IX coordinator oversees this complaint process. Slide 16 speaks of training. Training shall be provided to all staff. The Office of EEO and Title IX compliance will coordinate the delivery of this training. Tammy spoke earlier about the relationship with policy JIC. The JIC mandates that any reports of bullying, harassment, or intimidation based on sex, sexual orientation, or gender expression, or gender identity, that will invoke the Title IX court considerations, and that will be forwarded to the Title IX coordinator to be handled in accordance with this policy.
I guess it's a general question as I read this. It says the language of appropriate disciplinary action. Can you just explain what that means? Where would we find out what the appropriate, it says including termination or expulsion of the student, but where would we refer someone to understand how those judgments are, what is considered appropriate disciplinary action?
It would have to be cross-referenced for students with the student code of conduct. And for employees, it's managed by labor relations and can include anything from a written reprimand, which would be unusual, up through termination. So it's really hard to spell out specifically what a violation will result in is because you have to evaluate each case on a case-by-case basis. So you look at an employee's longevity or tenure with the school system, whether there have been any other disciplinary actions, those disciplinary actions being based on discriminatory conduct of any way or some other conduct. And so you may have a teacher, by way of example, who was suspended for 5 days for, hitting a kid. Certainly in that case, then you would employ progressive discipline, whereas if you have a first-time offender, the 5-day suspension may be appropriate for that person. It also depends on the circumstances or facts of the case, how long it's occurred, whether it's a one-time quid pro quo sort of sexual harassment case or one that has been long-standing in nature, one that may have affected more employees at the schoolhouse, such as a male or female employee who has said inappropriate comments to a number of people versus one person, whether the principal has talked to that person, whether they've undergone the sex discrimination training that we offer over the web. So again, it's really hard to narrow what the disciplinary action will be because so many variables determine what the appropriate action should be. The law requires that it is remedial in nature. And so that's one of the guidelines that the Labor Relations Office will keep in mind in assessing what the appropriate discipline is.
Yeah, I'm just struck. It's a little weak, but it's when you read it, it seems weak. But I understand it's a
Yeah.
case-by-case basis, depending on the student code of conduct and the employee, the employee relations. So I get that. So
So is
Thank
there
you.
a suggested language?
no, there's not. I just
Okay.
I was mulling it as you were saying it, and I will continue to mull it, but I don't
Okay.
have a
And
suggestion.
we will as well.
Yeah.
Okay.
I just want to add to what you just said. Everything that you just said is probably exactly what you do. I think that it's kind of critical that we document what you just said,
Okay.
because you have a lot of experience with this, and it could go so many ways. But when people see it in writing, or when we can see it in writing, the rules and regulations, and how do you determine and make a decision, I think that you need to bullet some of that in the document, because it can cause a lot of legal issues if you don't put some of that information.
So do you mean with regard to students
Students
or adults who are accused of the wrongdoing?
I think both.
Okay.
I think both, because if you say some of the information is referenced to previous experiences and incidents, I think some of that, and a little bit more detail in it, I think that needs to be there, because I've seen cases where people can, if it's not there, it's said that you didn't document, you didn't say this, if it's not written.
Well, so, yeah, in my experience, what attorneys often do is put the most severe disciplinary action in there, which is why we put the up to and including termination, because anything lesser is ordinarily what an employee wants. I certainly don't have any objections to listing variables that can be included. My concern is that it won't be exhaustive. And then folks will say, well, you didn't say you were going to consider blah, 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 blah. And then you get into the argument of, whether there's a one-size-fit-all. And in the discrimination world, it really isn't. You have to be fair in considering all of the information. But again, there's no one set penalty other than for the most egregious cases where you go straight to termination.
I know that you've worked with Community Relations Commission on issues. You've worked it, right, Tammy?
Yes, I have. So I represented.
Right, and I was the chair of that for 17 years, and I've seen where we missed, even for any organization, any division, we missed putting some information down, and it was used against us, and I just think that if we can possibly make sure that we have as much information documented, so it can be said that we didn't say it,
So
and we didn't include it.
And thank you to AJ for pointing this out. So if you look at, when you have a moment, JBBRA, and it talks about remedies available to, it says, including but not limited to, voluntary
Okay.
counseling and advocacy, transfer, JBBRA, RA,
the regulation itself.
transfer to another school,
Okay,
ability to make up assignments, counseling, suspension, expulsion,
Okay.
training, reprimand, revocation of certificate, and termination.
Okay, so that's in the regulation.
So, I mean, it includes what the end result might be. What I hear you asking is, can we include the criteria that could be considered in determining it? And, you know, again, I don't have an objection to putting very general language in there.
Okay.
I just don't want
Too
folks
much.
to believe that if it isn't listed, it won't be considered.
okay.
Because what someone will say, you know, having practiced this employment law for a lot of years now, is you didn't say what Johnny did in 15-16 school year would be relevant.
Okay,
Well, it is relevant if Johnny did it in the 15-16 school year, 16-17, and now 17-18, and he's gone from a one-day suspension to a 10-day suspension or an expulsion,
okay.
and now we want something more severe. And so I don't know that there is a way to advise parents of every contingency that is possible. But I see that as the role of the folks who are working with us on determining what the appropriate
Right.
disciplinary action is. And you know that through the disciplinary action process, there are several bites at the apple, and that the parents get to meet not only with the principal in some circumstances, but also the suspension coordinator, and then Dr. Garnett, who serves as Dr. Sandalisa's designee. With regard to employees, they have an opportunity to be heard by the investigator. They have union representation
Right.
or an attorney, who represents them. They have a hearing with the Office of Labor Relations, which is called a Loudermill hearing. And then they lastly have a right to appeal whatever decision Dr. Sandalises makes to the board and be heard by a hearing officer. So I've not heard of any instances with city schools where folks don't understand what could happen. But your
Okay.
point's well taken.
Okay.
One way to possibly address some of the concerns that I think are behind your question is, I'm sure there's record keeping of, here was the action, any prior actions, here was the consequence, and a periodic audit of those to ensure that we're being consistent in implementing the consequences for actions. Would that help? I mean, I'm sure that,
Yes, so that information is ordinarily housed in labor relations with regard to employees. In the past, we had what was called the discipline committee meeting, and a group of the chiefs sat around and determined, based on the individual facts of a case and an employee's record, what the recommended sanction would be. And in those cases, we certainly cross-referenced. You know, we had an adult who made an inappropriate comment to another adult at school X. What did we do? But again, you also have to cross-reference that against what prior disciplinary action there may have been, how long the person's been with the school system, you know, who the comment was made to. And there is a compliance report component. And I believe those reports will be coming to you on ACA or ACC mid-July, maybe early August, so to give you an idea of what sort of compliance information would be included in JBB.
Okay. Thank you.
Yes, ma'am.
I guess I had said a follow-up to that,
Okay.
because I'm on the regs right here, and it says, so if this is an employee who it says possible discipline, it just seems so wishy-washy. It says possible disciplinary action city schools may impose. So possible may impose against employees include but are not limited to. And so it just gives us the maximum amount of wiggle room of what to do but is there any way that we can say that disciplinary action will be imposed against employees that have been found culpable, and which may include, or in some clause that say that we're going to, with this appropriate to the level of the
So-
infraction type
So
of thing?
here's the issue with that in part. Reprimands are not considered disciplinary action.
Okay.
And so if you have an employee
Yeah.
who has been here, by way of example, 25 years, and they say to a colleague, "You look hot in that dress," which many people consider to be inappropriate. That is not sexual harassment. And so there wouldn't be any disciplinary action imposed. If, by example, that employee made a comment that was far more offensive, and you have a tenured teacher again, been here 20 years, everybody agrees that the one-time comment was completely inappropriate. Is it always appropriate to say that that person will get a suspension, which is discipline, versus a reprimand? If that person, by way of example, says, I'm really sorry, as soon as it came out of my mouth, I knew it was wrong. I've never done it before. I'll never do it again. I've completed the training. He has proficient on his evaluations. And so what I'm just trying to share is, we're not going to always impose disciplinary action.
Well, that's what the language says.
It says may.
Right, but then,
It says may.
so when we say then action, I guess I'm trying to take the word disciplinary, because we have disciplinary actions in here we have actions in here that are not considered disciplinary, meaning reprimands and training. But we are, I guess, I'm just trying to figure out, I'm speaking as a board member, want to feel that we're being as strict as possible for people who are are found culpable. And that there is I guess, I get that there's the appropriate level, and we can't be laying out every instance, but it seems to me that we wouldn't have to do anything here. But the way that it says, we could choose these, but we're not limited to, and we don't have to. And I think I want us to say that if they are found culpable, we will do one of these things.
I hear you, Peter.
Yeah.
Commissioner Cantor, sorry. And I understand and appreciate the protecting of students and employees who may be victims, but there's also a human element to I just said something stupid, or that doesn't need to be sort of on my permanent record. I certainly need my administrator to say to me, that's not okay, and I may need to apologize, but that shouldn't
But then you'd
have to have any consequence bigger than that necessarily.
then you get a reprimand.
Right.
Which-
So that's what
which
it's
is-
saying you can do.
It says it's possible, we may. What I'm saying, we will. No, we will. We will give one of these if you are found that you have been given some level of discrimination.
Got it.
Okay. We will do one of these things.
Okay.
And so my thing is,
At minimum, there'll be a conversation.
Got it.
Is that?
Okay.
I just want to say something for somebody who's taught in an Orthodox Hebrew school. Saying something like what you just said would require a discipline, because it's all according to the situation and who you're saying it to. So what you're saying, I'm along with what you're saying. It requires more than just, I'm sorry. It requires a serious reprimand. If you say something, you look hot in that dress, it could be very offensive to some people. Because of religion, it could be, So anyway, just to get back to, it's not clear what you just said. You mentioned that some of this is not clear, but I just want to say it can be very serious if you say something.
And again, that's because you're taking the environment, the circumstances under which it occurred into account. But I hear Commissioner Cannon, we can look at that, and we can certainly, and I'll look at the language again, but saying disciplinary action shall be taken where culpable or where there's a substantiated finding.
something,
It could just be a letter in your file. It could be very minimum or whatever.
Okay.
But anyway, I think it's open I think we should at least acknowledge that there's different situations that require different types of results.
Yeah, so what I'm hearing is that we want to be clear in communicating that infractions of this nature are taken seriously.
very seriously.
Right.
And so, by virtue of having this policy, I think we do that in many ways, but we can certainly strengthen the language in a way that doesn't place the system at risk, but also advises employees that this is an area in which you want to understand the guidelines under which you should operate and communicate with students and/or colleagues.
I'm good, thank you.
Okay.
You captured
Okay.
my with the way that you were thinking about it, thank you.
Mr. Parker, if you could go to slide 11. I have a question, just wondering if it is legal language on the fourth bolded bullet. failure to conform to stereotypical notions of masculinity or femininity. And if that is not the legal language that must be used, if there's a way we could phrase that in the affirmative, rather than someone failing to be stereotypically female or stereotypically masculine.
So that is how sexual discrimination is ordinarily defined under the law, but, I see no reason that we can't fine tune it. I guess I'm wondering how you would like to see it, because Clarence and I, as well as Tasha Barnes, who was the prior manager of EEO, thought through this language and looked at a couple of iterations, and none of them seemed to, in my humble opinion, convey what the language that is used by other entities that have discrimination policies and the case law communicates.
I would, I'd suggest doing some digging. Some things that come to mind would be something respecting diversity of masculine and feminine identification or expression. It just seems like this is negative about the person, and in of itself as a statement is discriminatory. Failure to conform to stereotypical notions of masculinity and femininity. So,
Does nonconformance help any?
it might. I would reach out to GLSEN and ask them what language they would use, so that the GLSEN, the
Mhm.
Gay Lesbian Straight,
Mhm.
and just simply say, hey, we're doing this policy. What language would be appropriate to use, or to the HRC, what language are they using?
Yeah, I mean, we can do that, but we also have to make sure that the policy is written in a way that the common school system employee understands what we mean.
Right,
And
but
so, if we get into some terminology where they're calling Clarence to say, well, hey, what does that mean?
Right.
I don't know that we can effectively implement it. But
yeah,
we hear you.
so we could, and I can think some more about it.
Okay.
It feels like bullying in and of the language there, so I think we need to address that. And then that was it. That was the last question.
Okay.
Oh, I have a question on the form, if it's appropriate to go to form questions. There's a grammatical error on the first line that needs to be corrected.
Is that on Form 1 you're talking about?
Form 1, yes, apologize.
JB,
It says directions, : if you are a student, or there needs to be,
Where are you? Can you just tell us where you are?
on the form,
JBARA Form 1?
correct,
Number.
Form 1.
or student,
Thank you.
or the parent or guardian of student.
So it says directions,
Mhm.
if you are a student or the parent guardian of a student. So if you are a student,
Oh, there's, okay.
so it's just
Just a typo.
just a typo.
Okay.
And then the other piece on the
I
form,
shouldn't say just a typo.
right,
Yes, we'll correct the typo.
thank you, appreciate that. Yeah, I'm not trying to be picky, but I just don't want to, best foot forward.
Yeah.
The other question is, under date of incident, in making this form user-friendly, what do they do if it's an ongoing event?
Then you put date of incident and the word continuing. so
So
when these
maybe a
forms-
continuing or a one-time,
We can
so
do
they
that.
could circle
But
afterwards.
recognize these forms also are the basis upon which the first interview with the complainant is conducted.
Correct. And I understand that, and I also understand the compliance timeline initiating, things like that. I'm just looking at this as, I'm a 7th grade student, and the date of incident, this has been happening to me for 3 months.
So
So
just-
how do I express that in
Yeah.
that initial piece, not necessarily waiting till the narrative to do so?
So we'll put continuing in nature with a yes or a no.
Beautiful, that does it
Okay.
for me. Any other questions on this policy? Thank you very much, Mr. Park.
Thank you.
Date of first incident.
Yeah, or date of initial incident, or,
think that because it's the first incident, it's beyond 180 days.
I guess I have one more. Just, I guess it's the one thing that's been just gnawing at me, reading the form again over again. It's just like, I'm worried that our students who are being bullied or facing discrimination, sexually or otherwise, don't have the appropriate outlets to express, like to kind of express to the right person. And so I guess I understand. I read the policy that it's through the principal and they have to fill out this form. I just feel like, and I guess I don't know where it goes, but it's. Can we just take another second to talk about how our teachers trained in opening up those channels for students to be able to express themselves? I mean, is there something that we should say that says that, like I think Martha used the language that within the first month of school, teachers will be trained in this, so they know to cover this with all their students, type of thing. I'm just worried that this is very compliant, but isn't going to be really accessible to students who are experiencing something. So I don't know where it goes, but that's my concern.
I will confess that I don't either, because the Office of EEO and Title IX compliance doesn't have, the ability to train 83,000 students. And all of the teachers and administrators are already trained through our web-based training, so that they at least know how to notice what's going on. And certainly it'll be updated if and when the board elects to adopt these two policies, so that that is part of the training. I'm just not sure how this office rolls out training to
I guess
students.
it's not acknowledgement that they would do the training, but that we have acknowledged that all staff have been trained and cover it with their students in some way.
But what does cover it with their students?
Meaning that they would. You're not only trained in that that the appropriate staff personnel would. Homeroom teachers would say, if there is an issue that's happening within your school, you can always come to me, and this is the procedure on how you do that. This is the way that you do it. If you guys are feeling bullied or discrimination or XYZ, you come to me, and there's a form that you can fill out, and just you realize all my doors open. I'd want every school to figure out a way to communicate that with the students and not in a manual have this form.
Right, so I think we need to cross-reference it with JIC. And so
Yeah.
originally, JIC was to come to this board along with the sexual harassment, the sex-based discrimination policy, but for a number of reasons that just didn't happen. I think Amanda and Mr. Colling would probably be best able to address how that policy is rolled out to staff and what training they receive, but it's basically the same policy, except for by law through Title IX, we have to address it separately.
Right.
So we may already be addressing it through the JIC, with the caveat that JIC will now have to say that the Title IX coordinator has to be involved. I am not aware of any issues with JIC being rolled out, and that's JICA, which is our bullying, intimidation, and harassment policy, or students not knowing how to avail themselves of the procedures set forth in that policy. And I dare say it's probably also included in the family guide, although I'll check that. But before we make another presentation to the board, we'll talk to the policy sponsor for CHIC, just to make sure that students understand it. Because what we don't want, I don't think, is to confuse students and think that it's completely different for JIC and completely different for JBB, when really JBB is just parallel to JIC in that we got to address the Title IX parts.
Right.
Right.
That's why I want to make sure
Yeah.
they're parallel, and I want to make
Right.
sure that students are exposed and understand.
Okay.
And honestly, the students don't need to know the letters or the numbers. The students
Exactly.
need to know there's a safe adult in their building to go to
That's true.
and share. And all of this actually fits well in a standards-based, developmentally appropriate health curriculum. So if our students had a health education curriculum, as they should be having for compliance, information about, with little kids, what is good friendship, with older kids, what is, good and bad touch, those kinds of things are in that curriculum. And then that they know that there's safe people in their school. Because the forms are going to be filled out with the help of an adult, and things like that. So
Just one more thing that I'd like to ask, and I'd like to recommend, right here in Baltimore, we are lucky to have a nationally known author, a researcher, whose research is in bullying and issues related to harassment, right here in Morgan State University, Dr. Leah Hollis. So when you're doing all, the process and workshops and presentations, I would highly recommend that you invite her to come and speak, and she would be very happy to do so. And that would be for all employees, from the faculties, principals, and students.
Okay.
So, okay.
All right, thank you very much. AJ, do we have public comment today? Helen? Okay. All right, in that case, our next meeting is August 15th, where we will talk about policy FFA, the naming and renaming of a school facility, and JFA, residency, non-residency tuition policy. Anything else for the good of the group? All right, at 4:21 PM, we are adjourned. Thank you.
Meeting an hour early.